Hello everyone, this is another video of the Maxim game. In the prior videos, we have learned about three maxims: acta exteriora indicant interiora secreta, which means acts indicate intention; absoluta sententia expositor non indigit, which means a simple proposition requires no explanation; actio non dater non damnificata, which means an action is not given to one who is not injured. And we have also learnt about the applicability of all these maxims in the general laws and special laws, be it of substantive nature or of procedural nature. Now, the next video, or we can say that in this video, we will learn about how res judicata balances ubi jus ibi remedium. So let's start with the Maxim game. Before moving to the hows of this video, that is how the res judicata balances ubijus ibi remedium, let's learn about the basics. First, we'll see the maxim ubijus ibi remedium. We all know the meaning of the maxim ubijus ibi remedium is that where there is right, there is a remedy. Now let's see how this maxim starts. Let's delve into the very basics of this maxim. Every person in the society has certain rights and duties towards another person. Now, when he breaches the duty towards another person, that another person has a right to sue the person in the first place for the breach of such a duty. So, in simpler terms, the maxim means that if a person has a right, then that person has a remedy in case if such right is breached or infringed. This is how ubi jus ibi remedium works. For example, let's take the cases of torts. Suppose A has negligently done certain act which has caused breach of a right of B. Now B has the right to sue A with respect to such infringement of breach or of such a right. Therefore, when it comes to the applicability of the maxim, this maxim is a very common maxim and is used in general parlance. It can be made applicable to the procedural laws as well as to the substantive laws where the rights are created. Let's take the example of the law of contracts. Under the Indian Contract Act 1872, under section 73, it has been laid down that a party to contract is entitled to receive compensation for the damage or loss caused due to the breach of contract or infringement of any part of the contract. Likewise, in the Code of Civil Procedure 1908, there is a right to institute suits of civil nature under Section 9 of the Procedural Code unless and until the cognizance of which is expressly or impliedly barred. Now, let's delve into the basics of res judicata. So, the doctrine of res judicata is contained under Section 11 of the Code. The maxim upon which res judicata is based is of both public nature as well as private nature. It means that res judicata is based upon both policies of law, be it a private policy of law or the public policy of the society. In the first case, it is based upon the maxim res judicata pro verite occipitur, which means that a judicial decision must be accepted as correct. And in the second case, it depends upon the maxim interest republicae ut est finis litem, which means that it is in the interest of the state that there should be an end to litigation. So the latter maxim is based upon the public policy. Now, the doctrine of res judicata, as contained under section 11 of the Code 1908, is nothing but a manifestation of the doctrine of stoppel. It is an expressed form of stoppel which precludes the court from trying a matter in issue already adjudicated properly between the same parties under the same title. In simpler terms, it means that if a matter is already adjudicated on all the grounds, then the same matter in issue cannot be litigated between the same parties under the same title. The very fundamental of the doctrine of res judicata is that it wants to prevent the multiplicity of suits, and at the same time it wants to protect parties from running from pillar to post with respect to one single matter of issue. Therefore, it is based upon the maxim res judicata pro verite occipitur, which means that a matter once decided should be accepted as final. It should lead to the finality of the suit so that the parties do not run from pillar to post with respect to a single matter. Therefore, while protecting the multiplicity of suits, the res judicata, on one hand, protects the litigants from running pillar to post from one court to another upon the same matter in issue which has been already decided, and on the other hand, it snatches the right to sue as given under section 9 of the Code 1908. It acts as an explicit bar raised upon the courts to take cognizance of such matters in issue which has been already adjudicated between the same parties under the same title, and therefore stops the party to approach the court, which is actually a right rendered under section 9 of the Code 1908, that is the right to file suits of civil nature in the courts of civil nature unless and until it is expressly or impliedly barred. Now let's find out the relationship between res judicata and ubijus ibi remedium. So before knowing the relationship between res judicata and ubijus ibi remedium, let us learn about the maxim nemo debet bis vixere pro uno et idem. Now this maxim means that no person shall be vexed twice for the same offense or act. It finds its place within the concept of double jeopardy under Article 20 Clause 2 of the Constitution of India. It also draws its jurisprudential essence from the Hans Kelson's Pure Theory of Law and the policy of Grundnorms, where Grundnorm is the Constitution of India itself. It is also based on the rules of equity, justice, and good conscience, and it is also based upon private as well as public policy. Now, since the very purpose of this maxim is to avoid multiplicity of proceedings, it can be said that the doctrine of res judicata is also based on the rules of equity, justice, and good conscience because it acts as a bar to the remedy of institution of suits to avoid the multiplicity of proceedings. Let's take an example. A files a suit against B on a particular matter in issue under the title of ownership and tenancy. Now, A derives the right to file the suits under Section 9 of the Code of Civil Procedure 1908. Now, B files another suit against A on the same matter in issue under the same title. Meanwhile, the former case gets decided. Now, under Section 7, sorry, now under Section 11 of the Code of Civil Procedure 1908, the court is barred from taking cognizance of such a second suit because it will create multiplicity of proceedings and it will not create the finality of judgments, which is against the public policy. The public policy is that once a matter being adjudged, the judgment has to be final so as to put a limit to litigation. Now, if a party keeps on approaching the court on the same matter in issue again and again under the same title, then that will breach the public policy. Therefore, the doctrine res judicata stands as an immovable rock before the maxim ubi jus ibi remedium. So, up till now, it's very clear and understandable how res judicata acts as an immovable rock before ubi jus ibi remedium. That is how section 11 acts as an immovable rock before section 9. Now let's learn how res judicata balances ubi jus ibi remedium. Now we all know that res judicata is based on public policy and it is based on the principles of equity, justice and good conscience. We all know that doctrine of res judicata is a special expressed principle under the doctrine of estoppel, which stops the court to entertain matters in issue or suits already tried and adjudicated upon properly. It is just a branch of estoppel being manifested under section 11 of the code 1908 to put finality to litigation and to put an end to litigation. Whereas the maxim ubi jus ibi remedium is a general principle proposing remedy when the rights are breached. Now, both the maxims, be it res judicata or ubi jus ibi remedium, both the doctrine and the maxim is based on the grounds of private as well as public policy. Both are based on equity, justice, and good conscience. and both are based upon the simple rule of limitation to put limit to litigation. One gives the parties a right to institute the suits, whereas the other takes the right to institute the suits so as to put a limit to litigation and a finality to judgments. Now, we all know that where equity is at stake, the law follows the principle of equity, justice, and good conscience. The doctrine of res judicata is also revolving around the rule of equity. It being a branch of estoppel, which is itself a principle of natural justice, which is based on equity, justice, and good conscience. The reason being that the doctrine res judicata revolves around the simple policy to put limit to litigations and give finality to judgments. On the other hand, ubi jus ibi remedium is also based on equity, which allows the party to come to the courts to institute suits upon the matters of civil nature. Under Section 9, however, there is a mention of the wordings implied as well as expressed bar to the cognizance of such matters in issue, which are of civil nature, which has been already decided in a former suits. So it is also based on the rule of equity. Therefore, where equity is at stake, the law follows the principle of equity, justice, and good conscience. Now, let's take an example. Suppose A files a suit against B on the basis of ownership and tenancy rights, respectively. Now, what is the legitimate expectation? The legitimate expectation is that each and every matter in issue is clearly raised upon in the suit, and the court has properly seen into the matters in issue which can be made as an issue under the knowledge of the court based on the facts stated by both the parties. This is the legitimate expectation. Now, if the party had the knowledge of a certain fact in issue and did not raise the same fact in the same suit, then that will call for the case of constructive res judicata. Now, constructive res judicata is another topic which can be dealt in another video in elaborate manner, but not in this video. Let's skip the concept of constructive res judicata in this video. So, as per the doctrine of legitimate expectation, each and every fact has been raised and matter in issue has been framed on the basis of the facts in issue, and the matter gets decided. Now, meanwhile, the decision was pending in this particular suit. B filed a suit against A on the same matter in issue under the same title, but raised an issue of objection as to jurisdiction. In the subsequent suit, it says that the decision in the former suit was based on lack of jurisdiction and it was an erroneous decision of law. Therefore, the decision should be set aside because it was on erroneous decision of law. Now we cannot stop the party who came in the subsequent suit on the ground of res judicata that a similar matter in issue has already been litigated and decided, and there has to be a finality of judgment. Why? Because it has to be based on the rule of equity, justice, and good conscience. We all know that procedure is nothing but the handmaid of justice. If procedure is the handmaid of justice, then equity overrules the procedure. And therefore, in this case, the subsequent suit will be dealt and decided upon, and no bar of res judicata will apply. And this is how the doctrine ubi jus ibi remedium gets balanced by the doctrine res judicata. This is how the doctrine res judicata, being just a handmaid of justice, being a procedure of law, has to maintain the rule of equity, and where equity is at stake, the law follows the principles of equity, justice, and good conscience. Therefore, the Section 9 of the Code of Civil Procedure 1908, being based on the maxim ubi jus ibi remedium, which allows remedy for any breach or infringement of the right, prevails over the doctrine of res judicata in all those cases where equity is at stake. Because when equity is at stake, the law will follow the equity, and it will revolve around the principle of natural justice, which is based upon equity, justice, and good conscience. This is how res judicata balances ubi jus ibi remedium. You can contact me at shrutipande.alsn@gmail.com. I appreciate your time. Do like, share, and subscribe. Thank you.